Now, Article 45(3) of the Kenyan Constitution guarantees that parties to a marriage are entitled to equal rights at the time of marriage, during the marriage, and upon its dissolution. This constitutional provision is reinforced by the Matrimonial Property Act of 2013, which establishes that both spouses have equal rights to matrimonial property. Now, as a judge, how would you distribute the property of a polygamous man who died intestate, where the first wife claims that some of the property subject of dispute were acquired before the deceased marriage to the second and third wife?
Thank you, AG, for that question. So it is true under Article 45(3), it calls for equality of the spouses, both at the beginning, during, and dissolution of the marriages. So it's a polygamous man, right? The question talks about a polygamous man. So I will invoke Section 40 of the Law of Succession, where the estate is divided among the houses according to the number of children in each house, with each wife counted as a unit. That will be my first part of the question. And if it's a polygamous marriage, it will look at the wife who was living in that. I will define what a matrimonial home is. And if that counts as part of the matrimonial home.
My question was, this man is married to one wife. They hold property. After some time, he marries the second, then the third. He dies intestate. How would you distribute the property that the first wife is alleging was acquired when there were two, before the second and the third wife came to the scene?
Her share will just be limited upon proof that that property was the one she acquired with the spouse when he was living.
How would you distribute?
I will distribute equitably based on their contribution, both monetary and non-monetary. And it's not an arithmetic test as was established in the case of Rono against Rono. So it will only be pertaining to her interest regarding the properties she acquired with that man during his lifetime before the other spouses came on board.
What about the property that each wife came with?
The property that each wife came with,
yes.
You'll have to establish what interest or what contribution she did to those properties. If she cannot prove she contributed to it, whether monetary or non-monetary, then she will not be entitled.
If you are married as a second wife and you come with a house, how would it be treated?
That property will be treated as your own. If they cannot prove that they contributed to it, whether monetary or non-monetary. You came with a house, right? But did they do any other thing to its contribution? Maybe they did non-monetary, maybe renovations, they added something to it. If they cannot prove it, then the house will just belong to you.
Thank you, Honorable Chief Justice. One or two questions from me, Wakili. Now, in the area of division of matrimonial property, you have a husband and wife, and they have shares in a company. Say the husband has 70%, the wife has 30%. Their marriage has hit headwinds. How would this property be divided between the two of them, the husband and wife? And the only property they have is that limited liability company with that shareholding of 70 and 30.
Thank you, Judge, for that question. So their marriage has come to an end, and under Article 45(3), the equality provision still prevails at the beginning and during and the dissolution of the marriage. Despite having 70 and 30, the wife has to state what contribution she did so that she'll be entitled to more. It's not an arithmetic formula of 50-50 is an equitable distribution. So she will need to prove what other things she did non-monetary for her to be entitled to more in the division of that asset.
Supposing she never made any contribution at all.
Then she'll just be entitled to what she had initially.
All right. Fair enough. Now, let's again assume we have a situation of a husband and wife, and they are both Muslims. They have been married. Again, their marriage has hit headwinds. And in the course of that marriage, the wife converted to Christianity. And now this marriage needs to be dissolved. Where do they go for the dissolution of the marriage? One has become a Christian, the other one is still a Muslim. They contracted an Islamic marriage.
Thank you, Madam Judge, for that. Actually, unless the man does not want to be married to her anymore, and the Islamic law, nothing stops him to continue living with her, despite converting to Christianity. Despite that, they can just go to the High Court for the dissolution of the marriage, because under the Qadi Courts, Section 175, the jurisdiction is to those who profess the Islamic faith. So she can opt out and submit to the jurisdiction of the High Court for the dissolution of their marriage.
Supposing the position was to be reversed, it is the man who has converted to Christianity.
If the man converts to Christianity
And the wife is still a Muslim.
and the Islamic law, then that marriage is automatically dissolved. So she can go to the Qadi Courts asking for dissolution of that marriage on grounds that he has left or deserted the religion.
All right. Thank you. That's all from me, CJ.